October 15th, 2019, inside courtroom 7 of the Cuyahoga County Family Court in Cleveland, Ohio, a man in a perfectly pressed gray suit turned to his attorney, leaned back in his chair, and burst out laughing. Not a nervous laugh, not an uncomfortable, out-of-place laugh. A deep, full, satisfied laugh, the kind that fills a room and tells everyone in it exactly what the person laughing thinks of the situation. And at that moment, every person sitting in that courtroom turned to look at him. The bailiff turned. The court reporter turned. The spectators turned. And the one person who did not turn, the one person who sat completely still, hands folded on the table in front of her, was the woman sitting across the aisle from him. His wife of 18 years. The woman he had spent 2 decades telling she was not capable. The woman he had spent 2 decades telling she would never survive without him. The woman he had, in the hallway of that very building 2 days earlier, dismissed with 4 casual words that several people in that building overheard and later remembered. He had said, "She can't fight me." What happened next, in the 60 seconds that followed that laugh, is the reason we are here today. Because the judge looked up from her bench, and the room went completely silent. And she said 4 words back, 4 words that ended 22 years of a man believing the rules simply did not apply to him. 4 words that changed the financial futures of 2 children, shattered a carefully constructed public image, triggered a state investigation, and sent a woman who had been told she had nothing walking out of that courthouse with everything she was owed. This is not a simple story. This is not a story about a bad marriage or a messy divorce. This is a story about power, about financial control, about what happens when someone spends nearly 2 decades quietly dismantling another person's ability to believe in themselves, and about what happens when that person finally remembers who they were before the dismantling began. Stay with me, because every chapter of this story is more extraordinary than the last. Before we go any further into this story, we want to hear from you. Before we go deeper, let us know in the comments where you're watching from. We would love to hear from you. And if you are new here, please hit that subscribe button right now so you never miss any of our upcoming videos. Stories like this one are what we do here, and there are many more coming that you will not want to miss. Now, let's go back to the beginning. Because to understand what happened in that courtroom on October 15th, 2019, you need to understand the 18 years that came before it. You need to understand a woman named Sarah. And you need to understand the man she married. Because the story of that laugh, and those 4 words, did not begin in a courtroom. It began in a suburb of Cleveland, Ohio, in the spring of 1999, when a 26-year-old nurse named Sarah Renner walked into a company party she almost didn't go to. Sarah Renner grew up in Medina, Ohio, a town of about 27,000 people sitting roughly 30 miles southwest of Cleveland. It is the kind of town where people know their neighbors' names, where the high school football team draws a crowd on Friday nights, where Main Street still has a hardware store that has been in the same family for 3 generations. Sarah was the middle of 3 sisters. Her father, Thomas Renner, worked at a Ford manufacturing plant for 31 years. Her mother, Diane, taught 2nd grade at a local elementary school for 24 years. By every account from people who knew her growing up, Sarah was the steady one. The reliable one. Not the loudest person in any room, but the one people gravitated toward when they needed someone to actually listen. Her childhood best friend, a woman named Joanna who has known Sarah since the 3rd grade, described her this way. Sarah was the person you called when everything fell apart, because she would be there before you even finished explaining what fell apart. She had that quality, that rare, particular quality of making the person in front of her feel like the most important thing in the room. Sarah attended Ohio State University on a partial academic scholarship, studied nursing, and graduated in 1997 with honors. She took a position at the Cleveland Clinic in 1998 in a cardiac step-down unit. The work suited her. Precision, calm under pressure, the ability to hold a frightened patient's hand while simultaneously managing a medication schedule with the focus of someone who understood that the details matter in ways that the people in the beds cannot always see. She was exceptional at her work. Her supervisors noted it. Her patients remembered her. She was, by the time she turned 26, quietly building the kind of life that looked exactly like what she had worked for. A good career, an apartment of her own, a small savings account, the beginnings of a future she had designed with her own hands. And then, on an April evening in 1999, Her colleague and friend Patrice called and begged her to come to a party at a downtown Cleveland restaurant hosted by a local contracting company. Sarah almost said no. She was tired. She had a morning shift. She had things to do. But Patrice was persistent in the way that only a truly good friend can be persistent, and Sarah went. And at that party, standing near a bar on the second floor of a restaurant overlooking the lights of downtown Cleveland, she met Derek Mitchell. Derek Mitchell was 29 years old at the time. He was the second-generation owner of Mitchell Comfort Systems, an HVAC contracting company his father had built from a one-truck operation into a mid-sized regional business with a solid reputation and a growing client base in the commercial sector. Derek was the kind of man who walked into a room and immediately understood its social architecture. He knew who to shake hands with first. He remembered names. He made everyone he spoke to feel like the most interesting person he had encountered in months. He had a wide, easy smile. He told good stories. He was physically imposing without being intimidating, tall, well-built, the product of 4 years playing college baseball at a Division III school in Western Ohio. He dressed well without trying too hard. He was, on the surface, nearly everything a 26-year-old woman who had spent the last 3 years working 12-hour shifts and eating cereal for dinner might find genuinely, disarmingly attractive. And when he turned that full attention on Sarah Renner at that party in April of 1999, she felt it immediately. The warmth of it, the weight of it, the feeling of being chosen. They dated for just over 2 years. In the early months, Sarah's friends and family adored Derek. He was attentive. He was generous. He showed up to family dinners with wine and remembered everyone's dietary preferences. He called when he said he would. He fixed things around Sarah's apartment without being asked. He took her to concerts, to weekends in the Finger Lakes, to Chicago for a long Thanksgiving weekend. Sarah's older sister Carol, who is 3 years older than Sarah and had always been the cautious one in the family, admitted later that in those early years she had thought Derek Mitchell was as close to perfect as any man she had met. He seemed to genuinely love Sarah. He seemed to want her to be happy. And Sarah, for her part, was happy. She was more than happy. She was the version of herself she had always wanted to be. Open, adored, building something with someone. They got engaged in November of 2000 at a restaurant in downtown Cleveland where he had arranged for the staff to bring out a dessert with a ring pressed into the side of the plate. She said yes before he even finished asking. They married on June 9, 2001, in a ceremony at a restored barn venue outside of Medina. 64 guests. White flowers, white tent, an Ohio summer evening that turned from warm to perfectly cool by the time the dancing started. Sarah wore a dress she had found in a vintage shop in Columbus and had altered by a seamstress in Medina. She kept it for years. She kept it even when keeping it made no sense anymore. Sarah's maid of honor was her sister Carol. Derek's best man was his business partner and oldest friend, a man named Ray Holloway. The photographs from that day show two people who are genuinely, fully present in the moment. Laughing, dancing, holding on to each other. Photographs do not show what a marriage is made of. They only show what a day felt like. And that day felt, to everyone present, like the beginning of a very good story. What actually began on that day would take 18 years to fully reveal itself. And when it was finally revealed, in the fluorescent light of a county courthouse, it looked nothing like those photographs. In the first years of their marriage, Sarah continued working at the Cleveland Clinic. Derek expanded the business. They bought a house in Westlake, a suburb on the west side of Cleveland, in 2002, a 4-bedroom colonial with a yard big enough for the children they talked about wanting. Their daughter Emma was born in March of 2004. Their son Tyler followed in November of 2007. By the time Tyler was born, the shape of the marriage had begun to shift in ways that were subtle enough to dismiss and persistent enough to feel. The first shift happened gradually, in the way that most significant changes in a long relationship do, not as a single dramatic moment, but as a slow accumulation of small adjustments, small concessions, small moments of choosing silence over conflict. Sarah had gone part-time at the clinic after Emma was born, which she had wanted to do and which Derek had supported enthusiastically. After Tyler arrived, Derek suggested she leave the clinic entirely. The children needed stability, he said. The household needed consistency. Between his business income and the demands of managing a home with 2 young children, the math made sense, he said. And Sarah, who was tired and stretched thin and genuinely devoted to being present for her children, agreed. She left the clinic in the spring of 2008. And in the months that followed, without fully recognizing it was happening, Sarah Renner Mitchell began to disappear. The disappearance did not happen all at once. That is the thing about this kind of process that most people from the outside genuinely cannot understand. It happens in increments so small that each one, taken alone, seems reasonable. Derek began managing the household finances in 2008 when Sarah left the clinic. This made practical sense. He was running a business. He was experienced with financial management, and Sarah had always been more comfortable with caregiving than with spreadsheets. She did not resist this. She barely noticed it as a transition. What she noticed, slowly, over the years that followed, was that asking for money for groceries started to feel like making a case. That mentioning she wanted to take the kids to the Science Museum on Saturday required a conversation about budgets that left her feeling like she had asked for too much. That the joint checking account she had access to was always just below the level that would allow any spontaneous decision. Derek was never cruel about money in any way Sarah could have pointed to and named in a sentence. He never yelled. He never threw things. He simply made the management of every dollar a conversation in which he was the final word. And over months and years, Sarah stopped initiating those conversations unless she absolutely had to. What Derek Mitchell was doing has a clinical name. Researchers and domestic violence advocates call it financial abuse, and it is a subcategory of coercive control, a pattern of behavior in which one partner uses money, access to resources, and financial decision-making as tools to restrict the other's freedom and independence. According to data from the Pennsylvania Coalition Against Domestic Violence, financial abuse occurs in 98% of abusive relationships and is the single most cited reason that victims remain in or return to those relationships. It is not a dramatic form of control. It does not leave bruises. It does not generate police reports. It generates, instead, a person who gradually loses the ability to picture their life without the person controlling them, because the mechanisms of survival, the bank accounts, the credit history, the work experience, the professional network, have been so quietly and methodically removed that leaving feels not just difficult, but genuinely impossible. Sarah Mitchell did not have a name for what was happening to her for most of the time it was happening. She only knew, somewhere beneath the organized routine of her days, that she had stopped being herself. She just could not quite locate the moment when it had started. By 2009, Sarah was keeping a journal. She had started it almost by accident. She had bought a notebook to write down Tyler's developmental milestones and had started, on the blank pages at the back, writing other things instead. Private things. The things she did not say out loud. In March of 2009, she wrote, "Derek checked my phone again tonight. He said he wasn't checking it, he just picked it up. I didn't say anything. I've stopped saying things. When I say things, it turns into something that lasts 3 days and ends with me apologizing for starting it. I don't know when I got so tired. I don't know when tired became the baseline." She did not show that journal to anyone for years. She kept it in a box of nursing textbooks on a shelf in the guest bedroom, a shelf Derek Mitchell had never once looked at. And she kept writing, page after page, year after year. A private record of a private life. A woman talking to herself because there was nowhere else for the words to go. The isolation was as gradual as the financial control, and they moved in tandem, the way two systems in the same weather pattern tend to move. By 2010, Sarah had stopped seeing her friend Joanna regularly. This had not been an argument. There had been no single incident. It was simply that when Sarah mentioned getting together with Joanna, Derek had a way of sighing that communicated, without words, that this was an inconvenience. A reorganization of his schedule, a demand on resources, his time, his help with the children, that he was not enthusiastic about supplying. Sarah began to feel that her friendships were a burden she was imposing on him. So she stopped imposing. She saw Joanna on birthdays and school events and the occasional holiday. And in between, the friendship that had once been a weekly phone call became an annual catch-up that left both of them feeling the width of the distance without being able to name what had created it. Her sister Carol noticed the change too. Years later, Carol would describe watching it happen as one of the most disorienting experiences of her life, because it was so slow and because Sarah always had an explanation that sounded reasonable. She was busy. The kids needed things. Derek had a lot going on. Carol could not find the single moment where the reasonable explanations stopped being true. Derek Mitchell's public life, during this same period, was expanding in every direction that his private life was contracting. Between 2005 and 2012, Mitchell Comfort Systems nearly tripled in revenue. Derek won a regional small business award in 2009. He sat on the board of a local chamber of commerce. He coached Little League for 4 consecutive seasons and was well-liked by the other parents in ways that Sarah found, over time, increasingly difficult to process. Because the man they saw at games and barbecues and school events was warm and funny and remembered everyone's names and their kids' names and sometimes their kids' pets' names, and Sarah would drive home from those events sitting next to a different man entirely. Not a monster, not someone who screamed or threw things or left marks. Just someone whose warmth had a location, and that location was public, and inside their house there was a different temperature altogether. A managed coolness. A silence that had requirements attached to it. A home in which 2 children grew up learning, by observation, what the rules were. Not written rules. Not spoken rules. The kind of rules that children absorb through the walls. By 2013, Sarah had no credit card in her own name. She had no savings account in her own name. The car she drove was registered in Derek's name. The house was in his name. Her nursing license, which she had maintained through continuing education credits she completed quietly at night after the children were asleep, was technically still valid, but she had not worked in a clinical setting in 5 years and was not sure how long it would take to get back to where she had been. She was, in the most practical and precise sense of the words, financially dependent on a man who used that dependence as architecture. A structure she lived inside without being able to fully see the walls. When she thought about leaving, and she thought about leaving, in the way that people think about doing the thing they believe they cannot do, she would run the numbers in her head, and the numbers would stop her every time. No savings. No credit. No job history. 2 children. A legal battle against a man who owned a business, had an attorney on retainer, and had spent a decade making sure that every financial decision ran through him alone. The numbers did not add up to freedom. The numbers added up to staying. So she stayed. The year 2017 changed something in Sarah Mitchell, and it changed it quietly, the way the most important changes tend to arrive, not as a lightning bolt, but as a slow and persistent light. Tyler, then 9 years old, was diagnosed with a learning disability in the spring of that year. It was a processing disorder that affected his reading and his ability to organize written work, and which required both educational support and advocacy on his behalf within the school system. The diagnosis hit Sarah hard at first, the way any diagnosis affecting your child hits hard, regardless of its severity. But what followed the diagnosis was something she had not expected. Sarah Mitchell, who had spent 9 years asking permission for grocery money and apologizing for wanting to see her friends, sat down across from a table of school administrators in October of 2017 and fought for her son with everything she had. She used clinical language from her nursing background. She cited educational law. She pushed back when they said his needs could be adequately met in a standard classroom without additional support. She returned to that table twice. She sent emails. She documented responses. She was, in those meetings, the version of herself that she had been at 26 years old, standing at a nurse's station in the cardiac unit of the Cleveland Clinic, knowing exactly what the patient in room 12 needed and prepared to advocate for it with every tool available to her. And she won. Tyler received the educational support he needed. And on the drive home from the final meeting with the school's special education coordinator, Sarah Mitchell looked in her rearview mirror at the road behind her and thought something she had not thought about in almost a decade. She thought, I'm still good at things. She pulled into the driveway of the house on Birchwood Lane in Westlake and sat in the car for 7 minutes before going inside. Not because she was upset, because she needed to hold that thought for a moment without letting it dissolve. Because that thought, that small, 3-word thought, was the most important thing she had experienced in years. Not a victory, not an arrival, just a reminder. A crack in a wall she had been living inside so long she had stopped noticing it was a wall at all. And in the spring of 2018, Sarah Renner Mitchell, 44 years old, no job, no savings, no credit, no way out that she could see, quietly and deliberately began preparing to find one anyway. She found a therapist first, a woman named Dr. Angela Reed, who practiced in a small office in Rocky River, Ohio, about 15 minutes from the house in Westlake. Sarah paid for the appointments with cash she had been carefully accumulating from the household allowance Derek gave her for incidental purchases, the kind of small amount she had learned, over years, how to reserve without it being noticed. She paid in cash because she did not want the appointments appearing on any financial statement that Derek might review. She saw Dr. Reed on Thursday mornings while Tyler was at school and Emma was at volleyball practice. She told Derek she was running errands. She sat in Dr. Reed's office for the first 3 sessions and talked about Tyler, about Emma, about the management of the household. She could not quite get to the things she actually needed to talk about. In the 4th session, Dr. Reed asked her a question that Sarah described, much later, as the question that unlocked the room. Dr. Reed said, "Sarah, when was the last time you made a decision that didn't require someone else's approval?" And Sarah opened her mouth to answer. And she could not think of one. Not one. Not in years. And she sat in that office and she began to cry. And she cried for 45 minutes straight. And when she was done, she said, "I think I need a lawyer." She called her sister Carol from the parking lot of a grocery store on a Tuesday morning in September of 2018. Derek was at a conference in Columbus. Emma was at school. Tyler was at school. The lot was mostly empty, and Sarah sat in the driver's seat of the car that was registered in her husband's name, and she said something she had never said to another human being. She said, "Carol, I think I need to leave Derek." The line was quiet for 2 full seconds. And then Carol, who had been watching her younger sister shrink for the better part of 15 years, said, "I know. I've been waiting for you to say that. But if you're going to do this, Sarah, you have to do it right." Carol had a friend whose sister had been through a difficult divorce 3 years earlier and had been taken apart financially in the process. The lesson from that experience, which Carol had absorbed and held on to without knowing why, was this: do not file until you have documentation, and do not find a lawyer until you find the right one. She told Sarah this. And Sarah, who had just made the most important phone call of her life from a grocery store parking lot, wrote it down in the Notes app on her phone, put the car in drive, and began. Finding Linda Marsh was not an accident. Sarah spent 3 weeks researching family law attorneys in the Cleveland area before she made a single phone call. She read case records that were publicly accessible. She read attorney profiles. She asked careful, casual questions of people she trusted. She was methodical about it in the way she had been methodical about everything important in her life: her nursing degree, her son's educational case, the hidden appointments with Dr. Reed. What she found, after 3 weeks of careful searching, was that Linda Marsh had a specific reputation in the Cuyahoga County family law community for taking cases involving financial control and hidden assets with a particular thoroughness. Her win rate in contested divorces was high. Her reputation among opposing counsel was for preparation so complete that experienced attorneys genuinely did not want to go to trial against her. She charged rates that were beyond Sarah's current means, but she had a payment structure for clients in exactly Sarah's financial position. Clients who were leaving marriages in which they had been systematically prevented from accumulating independent resources. Sarah called her office on a Monday morning in early October 2018, was given an appointment the following Wednesday, and drove to Linda Marsh's office in downtown Cleveland with a list of every question she had prepared over the previous 3 weeks. Linda Marsh, who had spent 19 years in family law, later said that in their first meeting Sarah Mitchell struck her as one of the most composed and focused clients she had ever encountered. She asked all the right questions. She had thought through the logistics. She was frightened, but the fear was organized. She walked in knowing what she needed, Linda said, and that is rarer than you'd think. The plan they agreed on in that first meeting was specific and careful and built around one central reality. The only way to make this filing stick, given the financial imbalance between Sarah and Derek, was to enter the courtroom holding something Derek did not know existed: documentation, evidence, the financial truth of the marriage, assembled before Derek had any reason to suspect it was being assembled. This was not dishonest. It was strategic. It was the recognition, as Linda explained it to Sarah in their second meeting, that a man who controlled every financial document in a household would, the moment he received divorce papers, begin managing what those documents said. The time to gather the real picture was before the filing, not after. So Sarah began gathering. She photographed bank statements when Derek left them on his desk. She photographed tax returns from the locked filing cabinet in the home office using a key she had made a copy of years earlier, during a period when she had been managing the household bills and Derek had not yet begun to view this as a problem. She opened a savings account in her own name at a bank across town, using a post office box she had rented as the address, and she deposited $40 a week from her household allowance. $40 that Derek, who was managing an 8-person contracting company and multiple client accounts, did not notice leaving the household budget. $40 a week. For 7 months. Until she had enough. And then, on the morning of January 14, 2019, Sarah Renner Mitchell filed for divorce. Derek Mitchell received the divorce papers at his office on January 16, 2019. His assistant brought them in with the morning mail. According to Ray Holloway, who was at the office that morning and witnessed the next 20 minutes unfold, Derek did not appear upset when he read them. He did not appear sad or shaken or caught off guard in the way that a man who had not seen this coming might appear. He appeared, according to Ray, calculating. He read the documents twice. He set them on his desk. He picked up his phone and made 3 calls. The first call was to his personal attorney. The second call was to his accountant. The third call was to Gary Whitfield. Gary Whitfield was a name well known in the Cuyahoga County family law community, though his fame was of a specific and instructive kind. He specialized in high-asset divorce defense, and more precisely, in protecting the financial interests of business-owning spouses in contested divorce cases. He had been practicing for 23 years. His firm had handled hundreds of cases. His approach was documented. His tactics were documented. And if you were a woman sitting on the other side of a case he had been hired for, the documentation was not reassuring. He charged $25,000 as an initial retainer. Derek paid it the same day he received the filing. In cash. 2 days after the filing, Ray Holloway heard Derek say it for the first time. They were in the parking lot of Mitchell Comfort Systems, standing by Ray's truck at the end of the workday, and Derek was leaning against the hood with his arms crossed. And he said it the way someone states a fact they have already fully processed. He said, "She can't fight me, Ray. She doesn't have the money. She doesn't have the documentation. She doesn't have anything I haven't let her have. She thinks she can walk into a courtroom and take half of what I built. She's going to figure out real fast how this works." Ray Holloway, who had known Derek since they were 20 years old and who loved him with the loyalty of a long friendship but was not without his own conscience, did not say anything in response. He nodded the way you nod when you do not want to have the conversation that would follow if you didn't nod. He got in his truck. He drove home. And he thought about Sarah, whom he had known for 18 years, and he thought about what Derek had said, and something in the back of his mind registered a discomfort that he did not name at the time. He would name it later, much later, when it was relevant. Gary Whitfield's strategy in the early months of the case followed a blueprint that Linda Marsh recognized immediately, because she had been on the receiving end of it before. Step 1 was to dispute the characterization of the marriage. Whitfield's initial filings described Derek as a devoted husband and involved father who had made generous provision for his family and who was now being subjected to a financially motivated divorce action by a spouse whose history of emotional instability called into question the reliability of her claims about the marriage. The phrase emotionally unstable appeared 3 times in Whitfield's first set of filings. Linda Marsh read those filings on a Sunday afternoon at her kitchen table with a cup of coffee going cold beside her and made a single notation in the margin. He's going to use her therapy records. She was correct. Step 2 of Whitfield's strategy was to contest the valuation of Mitchell Comfort Systems. His team argued that the business was entirely premarital in its origin, that Derek had inherited it from his father, that Sarah had contributed nothing to its development, and that its current value was not subject to equitable distribution as a marital asset. This was legally aggressive in ways that were technically arguable and practically transparent to any judge who had spent more than 4 years in a family court. Step 3 was the one that took Sarah's breath away when Linda called to explain it. Derek Mitchell was seeking primary physical custody of Emma and Tyler. He claimed in his filings that Sarah's history of anxiety and depression, documented in a brief treatment episode in 2011, combined with her prolonged absence from the workforce, demonstrated a pattern of instability that made her the less suitable primary parent. Linda Marsh, who had been practicing long enough to recognize a custody threat as a pressure tactic rather than a genuine parenting concern, explained to Sarah that this was strategic, that the purpose was not actually to take the children, but to create a second front in the legal battle that would drain Sarah's limited resources and emotional energy. "He wants you scared," Linda told her in their meeting in March of 2019. "He wants you spending everything you have, financially and emotionally, fighting for the kids, so you don't have enough left to fight for the money. That's the play." Sarah was quiet for a moment, and then she said something that Linda Marsh would later describe as one of the most clarifying moments in a client meeting she had experienced in 19 years. Sarah said, "He's been running that play on me for 18 years. I know what it feels like from the inside. Tell me what to do." What Linda Marsh told her to do, in that meeting and the several that followed, involved a process of financial discovery that would take months and require the kind of patience that only someone who had been living inside a very long con could sustain. Sarah needed to formally request financial disclosure from Derek as part of the divorce proceedings. Derek would have to, under oath, disclose all assets, all income, all accounts, all business interests. He would have to sign that disclosure. And then Linda's team would examine every line of it against the documentation that Sarah had gathered, against the tax records she had photographed, against the business filings that were part of the public record, and against the analysis of a forensic accountant. Linda recommended a man named Phil Garrett. Phil had been doing forensic accounting in divorce proceedings for 22 years. He was not dramatic. He was not showy. He was the kind of man who could look at a 7-year transaction history and find the thing that did not belong with the same calm precision that a cardiologist uses to read an EKG, not excited by what he sees, just very, very clear about what it means. Linda had worked with him on 11 previous cases. She trusted his work completely. Sarah signed the retainer for Phil Garrett's services using money from the savings account at the bank across town. The account she had built to $40 at a time over 7 months. She signed it with the steady hand of someone who understood they were using the only tool they had built themselves, and who intended to make it count. Phil Garrett received the first set of financial documents in May of 2019, and he spent the following 6 weeks doing what he did, sitting with the numbers, tracing the flows, looking for the lines that did not run where they were supposed to run. He reviewed personal tax returns from 2012 through 2018. He reviewed the business tax filings for Mitchell Comfort Systems for the same period. He reviewed the financial disclosure Derek had signed and submitted through Gary Whitfield, which listed the household accounts, the business account, one personal investment account, and the equity in the Westlake house. He compared these against the banking records that Sarah had gathered and against the business registration records he pulled from the Ohio Secretary of State's office. And then, on a Tuesday evening in mid-June 2019, Phil Garrett sat back in his chair, looked at the document on his screen for a long moment, and called Linda Marsh. Linda picked up on the second ring. Phil said, "Linda, I need you to sit down." And Linda, who had been in this business for 19 years and who did not rattle easily, sat down. And Phil Garrett told her what the numbers said. Between 2012 and 2019, Derek Mitchell had moved money through a series of limited liability companies that had no employees, no physical operating locations, no commercial purpose, and no presence on any joint tax filing that Sarah had ever signed. There were 7 of these LLCs in total. Phil had found references to them in intercompany transfer records buried in the business financials, had traced them through the Ohio Secretary of State's business registration database, and had matched them against bank routing numbers that appeared in a handful of transactions Sarah had photographed from Derek's desk in the years before the filing. The LLCs had names that sounded like commercial entities: MNC Services LLC, Bridgepoint Property Management LLC, Lakefront Consulting Group LLC, but behind each one, Phil found the same pattern: money flowing in from Mitchell Comfort Systems, money sitting, money occasionally moving to a personal account in Derek Mitchell's name that appeared nowhere in his financial disclosure. 7 LLCs, 7 years. The total amount that Phil Garrett could document, with the conservative precision of a man who would have to testify to every number in front of a judge, was $887,000. Nearly $900,000. Hidden. From Sarah. From their joint tax returns. And from the sworn financial disclosure that Derek Mitchell had signed in March of 2019. Linda Marsh was quiet for so long after Phil finished speaking that he said her name twice before she responded. When she did respond, she said, "He signed the disclosure, Phil." And Phil said, "I know." And Linda said, "He signed it under oath." And Phil said, "I know." Understanding what that number meant requires understanding a specific aspect of Ohio divorce law that is worth pausing on, because it is central to everything that happened next. Ohio is an equitable distribution state. This means that in a divorce, marital assets accumulated during the marriage, are to be divided in a manner that is fair, though not necessarily a precise 50-50 split. The court has significant discretion in determining what is fair, and that discretion is informed by many factors, including the length of the marriage, the economic circumstances of both parties, the contributions each party made to the acquisition and value of marital assets, and, crucially, the conduct of each party with respect to those assets. A spouse who deliberately conceals marital assets from the other spouse, and who then lies about those assets in a sworn financial disclosure submitted to the court, has not merely committed a tactical error. According to Ohio law, as interpreted in case after case by judges in the state's domestic relations courts, that spouse has committed fraud on the court. And as research from legal organizations studying hidden assets in divorce cases has consistently noted, a court that finds financial misconduct of this kind has the authority not only to award the concealed assets to the innocent spouse, but, in some jurisdictions, to award 100% of the hidden assets as a penalty for the concealment. Phil Garrett's documentation did not just give Linda Marsh ammunition. It gave her the case. The months between Phil Garrett's call in June of 2019 and the start of trial in October were the longest of Sarah Mitchell's life. She knew, after that call, what was on their table. She knew what the numbers showed. But she also knew, because Linda Marsh was honest with her at every step, that knowing something and proving it in front of a judge were not the same thing. Gary Whitfield was an experienced attorney. He would challenge the forensic analysis. He would challenge the methodology. He would look for the weaknesses in Phil Garrett's documentation and press on them with every tool 23 years of aggressive practice had given him. And the pressure on Sarah during those months was not just legal. It was personal, daily, intimate pressure. She was still living in the house in Westlake during the proceedings. She and Derek moved around the same kitchen, the same hallways, the same Sunday mornings, with the awareness that they were fighting a legal war that neither child could see, but both had begun to feel. Sarah kept Emma and Tyler close. She talked to them about change in the careful, honest, age-appropriate way that Dr. Reed had helped her practice. She drove them to school. She made their lunches. She attended their events. She was, throughout those months, the same mother she had always been. The one thing in her life that Derek's management had never touched, because her love for her children had never required his permission to exist. Derek Mitchell, in those same months, appeared in public to be exactly what he had always been. He attended community events. He hosted a summer barbecue for his employees and their families in July. He coached the last 4 weeks of the Little League season he had committed to before the filing. He was, to all appearances, a man proceeding through an unfortunate life event with composure and dignity. What was happening below that surface is what matters. Because Derek Mitchell, who was certain he was going to win this case, had made a decision in the early summer of 2019 that Gary Whitfield, when he found out about it much later, would describe in the carefully neutral language of an attorney speaking about something he clearly wished his client had not done. Derek had not moved the money in the 7 LLCs. He had not attempted to transfer it, dissolve the entities, or obscure the transactions any further than they already were. He had, instead, decided that the money was too well hidden to find. He had constructed what he believed was an impenetrable financial architecture, and he trusted it the way a man trusts a structure he built himself. He did not know about Phil Garrett. He did not know about the photographs Sarah had taken from his desk. He did not know about the Ohio Secretary of State database search or the bank routing number cross-reference. He knew that Sarah did not have the kind of sophisticated financial resources that could fund a forensic investigation. He knew that because he had spent a decade making sure she never would. He was, as October approached, as confident as he had ever been. And confidence, when it is this unexamined, when it is built on the certainty that someone else cannot fight back, tends to be the most dangerous thing a person can carry into a courtroom. The trial date was set for October 14, 2019. Cuyahoga County Family Court, Courtroom 7. Judge Patricia Hines presiding. Judge Hines had been appointed to the Domestic Relations Bench in 2008 after 14 years in private family law practice. She was 57 years old at the time of this case. She was known in the courthouse for three specific things. First, an almost complete intolerance for procedural delay tactics. Motions filed for the purpose of exhausting the opposing party rather than advancing the legal question were met in her courtroom with a directness that had left more than one experienced attorney feeling like they had forgotten something important. Second, an extraordinary ability to read the financial architecture of a contested divorce case, which was the product of her years in private practice and which she applied in her courtroom with the precision of someone who had seen every version of every tactic. And third, and this is the one that people who had appeared in her courtroom mentioned most frequently when her name came up, an almost total intolerance for contempt. Not legal contempt in the technical sense. Personal contempt. The kind a person showed when they believed the proceedings were beneath them. The kind a person showed when they could not quite conceal that they did not take the person across the aisle from them seriously. Judge Hines had grown up in a family that understood, in the most immediate and practical way, what it felt like to be dismissed. She had carried that understanding onto the bench, and it shaped, in ways both visible and invisible, everything about how she ran her courtroom. In the 2 weeks before the trial began, Gary Whitfield filed 3 pretrial motions. The first was a motion to exclude Phil Garrett's forensic analysis from evidence, arguing that his methodology was insufficient to meet the evidentiary standard for expert financial testimony. This motion was denied. The second was a motion to seal the Mitchell Comfort Systems financial records during the proceedings, citing trade secret concerns. This motion was also denied. The third was a motion to delay the proceedings by 60 days pending an independent business valuation dispute. Judge Hines denied this motion as well, in a ruling that was 4 paragraphs long and that concluded with a sentence which, to Linda Marsh's reading, suggested the judge had already formed a preliminary assessment of how the pretrial process was being managed. The sentence read, "The court finds no basis for further delay of proceedings in this matter and notes that the pattern of motions filed by the respondent has the character of procedural exhaustion rather than legitimate legal dispute." 3 denied motions in 2 weeks. 3 signals that any attorney with experience in Judge Hines' courtroom should have read clearly. Derek Mitchell did not have experience in Judge Hines' courtroom. Gary Whitfield did. And Gary Whitfield, according to a colleague who spoke about this case after it concluded, had a private conversation with Derek Mitchell in late September in which he recommended that Derek consider a negotiated settlement. Derek declined. He said he wasn't settling. He said he was going to win. He said the words that were becoming, by this point, almost a refrain, "She can't fight me." On the morning of October 14th, 2019, Sarah Mitchell got up at 5:30 in the morning. She made coffee. She sat at the kitchen table for 45 minutes in the quiet of the house before Emma and Tyler woke up. She had laid out her clothes the night before, a navy blazer, a gray dress, low heels. Simple. Composed. The clothes of someone who intended to be taken seriously. She packed the children's lunches. She drove them to Carol's house, where they would stay for the duration of the trial. She hugged Tyler for a long time in Carol's front hallway. He was 12 by then, old enough to know something important was happening, young enough to need the hug to mean something. She drove downtown. She parked 4 blocks from the courthouse and walked the rest of the way. She arrived 30 minutes early. She sat in the corridor outside Courtroom 7 and reviewed her notes. She had prepared for months. She had documented everything. She had answered every question Linda Marsh had asked her in preparation, including the hard ones, including the ones about the 2011 therapy episode and the depression and everything Whitfield was going to use. She was, as she sat in that corridor, as ready as she had ever been for anything. And when the bailiff opened the doors and she walked into Courtroom 7, she sat down at the plaintiff's table, folded her hands, and waited. Across the aisle, Derek Mitchell arrived 7 minutes later in a perfectly pressed gray suit, shook hands with Gary Whitfield, greeted the bailiff by name, and took his seat. He was relaxed. He was, by all accounts, almost cheerful. He leaned over and said something to Whitfield that made Whitfield smile thinly. And then Judge Patricia Hines entered the courtroom. Everyone stood. Everyone sat. And the judge said, "Let's begin." Gary Whitfield's opening argument ran 22 minutes. It was polished in the way that 23 years of courtroom performance makes an argument polished, smooth in its transitions, careful in its language, structured to land its most important claim at the beginning and again at the end, so that the person listening carries it out of the room. Whitfield characterized the case as straightforward. A successful businessman, a devoted father, a man who had provided generously for his family for nearly 2 decades. A wife who had chosen to leave the workforce, a choice he was careful to frame as mutual rather than directed, and who had been, as a result, fully supported by her husband's income throughout the marriage. He did not use the word dependent in a contemptuous way. He used it the way a careful attorney uses a word that means what it means, neutrally, in a way that nonetheless accomplishes something. He said that the petitioner, Sarah Mitchell, had been provided for generously, that she had access to a home, a vehicle, household funds, and every resource a person raising children in a comfortable suburban environment required, and that the current proceedings were the result of a decision that, while she was entitled to make it, did not transform a decade-long provision of comfort into a claim on the professional assets of a man who had built his business before the marriage and sustained it through his own effort throughout it. He sat down. Derek Mitchell nodded slowly at the table, still relaxed, still certain, and Judge Patricia Hines made a note. Linda Marsh's opening argument ran 11 minutes. She did not use adjectives where she did not need them. She did not describe Derek Mitchell's character. She did not reach for emotional framing in the way that Whitfield had reached for financial framing. She said 5 things, clearly, in the sequence that established everything that was going to happen over the next 2 days. First, this marriage had lasted 18 years. Second, during those 18 years, the petitioner had contributed to the household in documented, measurable ways, as a primary caregiver, as a household manager, and as a working professional for the first years of the marriage. Third, the petitioner had been, during those same 18 years, progressively excluded from all financial decision-making and denied access to the marital financial picture. Fourth, the court would hear evidence, from a qualified forensic accountant, that financial assets amounting to several $100,000 had been systematically excluded from the financial disclosure the respondent had signed under oath. And fifth, and she paused before this one, the way a person pauses when they want what they are about to say to land in a particular way, the court would have the opportunity to evaluate, through the evidence presented, not just what the marriage contained financially, but what it contained as a matter of character. And character, Linda Marsh said, looking briefly at Judge Hines and then sitting down, tends to reveal itself most clearly when a person believes no one is paying enough attention. Judge Hines wrote something in her notebook. Derek Mitchell's jaw tightened very slightly, and then relaxed. And Gary Whitfield, sitting beside him, did not look at his client. Phil Garrett took the stand at 2 in the afternoon on day 1. He was 53 years old, trim, with the composed manner of someone who had testified in court enough times to have stopped finding it stressful. He wore a plain dark suit and carried a folder of documents that was, by the standards of a courtroom, remarkably thick. Linda Marsh led him through his qualifications first, his 22 years in forensic accounting, his specialization in divorce asset cases, the number of cases in which his analysis had been accepted as expert testimony by Ohio courts. Whitfield offered a perfunctory challenge to his qualifications that Judge Hines disposed of in 2 sentences. And then Linda began walking Phil through the numbers. He explained his methodology. He explained the process by which he had identified the 7 limited liability companies registered under names affiliated with Derek Mitchell in the Ohio Secretary of State database. He explained how he had traced intercompany transfers from the Mitchell Comfort Systems main business account to each LLC through records obtained during the discovery process. He displayed charts on the courtroom screen. The charts showed, in a form that was both technical and undeniably clear, 7 years of money moving from one place to another, a place that appeared nowhere on any joint tax filing, nowhere on any financial disclosure, and nowhere in any document Derek Mitchell had acknowledged in this proceeding. The total amount Phil Garrett documented was $887,000. He said it the way he said all the numbers, flatly, precisely, without drama. The number sat in the courtroom air for a moment before anyone processed it. And then Gary Whitfield began his cross-examination. He was on his feet for 41 minutes. He challenged the characterization of the intercompany transfers as hidden income rather than legitimate business-to-business payments. He challenged the interpretation of the LLC structures as asset concealment rather than standard business tax management. He challenged the timeline, suggesting that some of the transfers predated the marriage and therefore could not be characterized as marital assets regardless of their nature. Phil Garrett answered every question with the same patient precision with which he had delivered his initial testimony. He had the documents. He had the routing numbers. He had 7 years of transaction history cross-referenced against public records, business registration databases, and the sworn financial disclosure that had been submitted to this court. Every answer Whitfield sought to complicate, Phil Garrett simplified back to the numbers. The numbers did not change under cross-examination. The numbers, by design, never do. When Whitfield finally sat down, Judge Hines looked at the exhibits on her desk for a long moment, then looked at the court reporter and said they would resume at 9 o'clock the following morning. And as the courtroom began to clear, Derek Mitchell leaned over to Whitfield and said something quietly. Whitfield's response was too low for anyone nearby to hear. But Derek's expression, as he stood and buttoned his jacket, was still the expression of a man who believed this was going to resolve in his favor. Whatever Phil Garrett had said about $887,000, Derek Mitchell had not yet fully accepted what it meant for the case. He thought he was winning. Day 2 of the trial began on October 15, 2019, at 9 o'clock in the morning. Sarah Mitchell took the stand at 9:15. She was dressed in the same navy blazer she had worn the day before. She sat with her hands in her lap and her back straight, and she looked at Linda Marsh and answered every question Linda asked her with the same quiet directness she had brought to every preparation session in the weeks before. She talked about the early years of the marriage. She talked about leaving the clinic. She talked about the financial arrangement that had developed in the years after she left, the household allowance, the single joint account with its consistent restrictions, the credit cards that were in Derek's name and that she used only with his awareness. She talked about the isolation. Not dramatically, not in the language of victimhood, but in the clear and specific language of a woman describing facts. She said, "When I stopped working, the financial access changed. Over time, I needed to ask for money for routine household purchases. Over time, the joint account I had access to had a level that didn't allow for any independent financial decision. Over time, I didn't have friends I saw regularly because the logistics of seeing friends required arrangements that created conflict." She did not use the phrase financial abuse. She did not use the word controlled. She described what happened, specifically, and let the accumulation of specifics build the picture that Linda wanted the judge to see. She talked about the children. She talked about Tyler's educational advocacy, which she had managed entirely on her own. She talked about the daily structure of the household, the meals, the school pickups, the medical appointments, the school events, the volunteering, the invisible management of 2 children's lives that did not appear on any financial statement and was not recorded in any business ledger, but that had been, for more than a decade, the full-time occupation of a woman with a nursing degree and a demonstrated capacity for organized, clinical thinking. She did not ask the court to feel sorry for her. She asked to see it clearly. And the judge, who had spent 11 years reading people in this room, was seeing clearly. Linda sat down, and Gary Whitfield stood up. He had 45 minutes of cross-examination. He was skilled. He was deliberate. He moved through his points with the experience of someone who understood that the goal of cross-examination was not to destroy a witness, but to introduce enough uncertainty around their account to erode the confidence of the person listening. He introduced the 2011 therapy records, carefully, establishing that Sarah had been treated for depression and anxiety. He asked whether her perception of events during that period had been affected by her mental state. He asked whether the household financial arrangement she had described as restrictive might more accurately be characterized as a mutual agreement, given that she had never formally objected to it in any documented way. He asked whether her characterization of the marriage was shaped by her current interest in the outcome of the proceedings. Sarah answered each question. She did not raise her voice. She did not cry. She did not become defensive in the way that Whitfield's questions were designed to provoke defensiveness. She was, on that stand, the most composed version of herself she had ever been in a public setting. Composed not because she was not feeling anything, but because she had learned, in 18 years of managing herself in a household that required management, how to hold a great deal inside a very steady exterior. And then Gary Whitfield said the thing that the room had been building toward. He said that Sarah's entire account of the marriage needed to be understood through the lens of an emotionally compromised woman whose perception of events had been distorted by the mental health struggles documented in the records before the court. He used the phrase emotionally compromised. He used the phrase distorted perception. He said these things in the smooth, precise language of someone who had said them before and who believed they would accomplish what they were designed to accomplish, which was to make a woman who had just told the truth in a courtroom sound like a woman who could not be trusted to know what the truth was. And then Gary Whitfield sat down. And from the table across the aisle, in the silence that followed the end of his cross-examination, came a sound. Short, low, satisfied. Derek Mitchell laughed. It was not a long laugh. It was not a performance. It was the completely unconsidered, unguarded expression of a man who believed, at that moment, that he had just watched something conclusive happen, that the question about distorted perception had landed the way he wanted it to land, that the thing his attorney had just done was the thing that ended this. He laughed the way a man laughs when he is certain he has won and is allowing himself a single private moment of acknowledgement before the formalities catch up. It lasted perhaps 2 seconds, and in those 2 seconds, every person in that courtroom who had not already been watching Derek Mitchell turned to look at him. The bailiff, the court reporter, the 3 people in the spectator area. Linda Marsh, who was already looking at him, made a note and did not change her expression. Sarah Mitchell, on the stand, did not move. She looked at a point in the middle distance the way someone looks when they are choosing very carefully what their face will do next. And Judge Patricia Hines looked up from the notebook in front of her. She looked at Derek Mitchell with the particular and practiced stillness of a person who has spent 11 years being the authority in a room and who knows, with complete certainty, that she does not need to raise her voice to make a point. She looked at him for 1 full second, and then she said 4 words. "Mr. Mitchell, control yourself." She did not say it loudly. She said it the way a surgeon makes a precise incision. Minimal force, maximum effect, absolute clarity about where the instrument is going. The room went completely silent. Gary Whitfield put his pen down. Derek Mitchell's expression, which had been somewhere between amused and satisfied, underwent a visible change. He straightened in his chair. He looked at the judge. He said, quietly, "I apologize, Your Honor." And Judge Patricia Hines held his gaze for 1 more second before returning to her notebook. And in that second, in the space between his apology and her return to her notes, something in the case changed. Not technically, not in any legal document, but in the room, in the accumulated atmosphere of 2 days of testimony and argument and evidence and 2 tables facing each other across an aisle, something settled. The judge had seen Derek Mitchell, not the businessman, not the Little League coach, not the man in the good suit who remembered everyone's names. She had seen the man who laughed at his wife's testimony in a courtroom while his attorney was suggesting she was too emotionally unstable to be trusted. And Judge Patricia Hines, who had spent 11 years on the bench and 14 years before that watching exactly this dynamic play out in conference rooms and mediation sessions and courtrooms and hallways, was not going to forget what she had seen. Closing arguments were presented on the afternoon of day 2. Linda Marsh went last. She stood at the podium and spent 17 minutes walking the court through the evidence in a sequence that was both methodical and, in its accumulated weight, devastating. She reviewed Phil Garrett's findings. She reviewed the 7 LLCs. She reviewed the total amount of hidden assets. She reviewed the signed financial disclosure and the specific items that had been omitted from it. She reviewed the pattern of financial control that Sarah Mitchell had described over 18 years, control that had rendered Sarah financially unable to leave a marriage she had wanted to leave, and that had been structured, she argued, with the explicit purpose of maintaining that inability. And then she talked about what the court had witnessed that morning. She did not call it contempt in the technical, legal sense. She said that the court had seen, in a single unguarded moment, the same dynamic that had been the subject of 3 days of testimony. A man who did not believe that his wife's experience was real. A man who had never been required to take her seriously. A man who was still, even here, even in this courtroom, expressing that belief in the only way he had left, a laugh, at the moment when his attorney was suggesting she could not be trusted. What this court witnessed this morning, Linda said, her voice steady and unhurried, is not separate from this case. It is this case. Your Honor, I ask you to show my client what the law is capable of providing when a person finally finds the courage to ask for it. Derek Mitchell's closing, delivered by Whitfield with characteristic skill, took the position that the forensic analysis was disputed, that the LLC structures were legitimate business instruments, that the financial disclosure had been prepared in good faith, and that the characterization of the marriage as abusive was a strategic narrative constructed after the fact to influence the court's equitable distribution analysis. Whitfield was good at his work. He was precise and unhurried, and he landed his arguments cleanly. When he finished, Judge Hines thanked both attorneys. She said she would issue a written ruling within 30 days. She struck her gavel, and the case of Mitchell versus Mitchell entered the waiting period that, for Sarah Mitchell, was the longest 30 days of her life. She moved out of the Westlake house the day after the trial concluded. She and the children had been staying at Carol's house intermittently during the proceedings, and after day 2, they did not go back. She packed what she needed in 2 trips. Carol drove the second trip. Sarah took the children's things, her clothing, her nursing textbooks, the box where she kept her journals, and a framed photograph from Emma's 5th birthday party that she had always loved. She left everything else. She rented a 2-bedroom apartment in Rocky River, 20 minutes from Carol's house, using a cosigner arrangement that Linda Marsh had helped her set up. The apartment was smaller than anything she had lived in since her 20s. It had a kitchen that faced east and got morning light that hit the counter in a way she found, in those early weeks, unexpectedly good. Tyler had his own room. Emma slept on a pull-out in the living room with a curtain they hung for privacy, in which Emma, being Emma, decorated with string lights and a poster from the Cleveland Art Museum. It was not the house on Birchwood Lane. It was hers. Or rather, it would be, in some new sense that was still taking shape. It would be. The ruling arrived on November 18, 2019. Linda Marsh called Sarah at 8:15 in the morning. She said, "I have the ruling in front of me. Are you somewhere you can talk?" Sarah was in the kitchen of the Rocky River apartment. The morning light was on the counter. The children were at school. She sat down on one of the 4 chairs she had bought at a second-hand furniture store 3 weeks earlier. She said, "Tell me." And Linda Marsh told her. The ruling was 43 pages long, which is notable in itself. A 43-page ruling in a family court divorce case is not standard. It reflects a judge who had something specific she needed to say, and who wanted to say it in a way that was legally complete and documented and could not be read casually or dismissed. Judge Patricia Hines began by establishing the facts of the marriage. She noted the length of the union, the financial contributions of both parties, the distribution of caregiving responsibilities, and the trajectory of the petitioner's professional life in relation to the decisions made jointly and unilaterally during the marriage. She noted that Sarah Mitchell had left a professional career at her husband's encouragement and had, over the following decade, been systematically excluded from financial participation in the marital estate. Then Judge Hines addressed the financial disclosure. She found, based on Phil Garrett's testimony and the documentary evidence submitted, that Derek Mitchell had knowingly and intentionally omitted significant marital assets from his sworn financial disclosure. The word she used was knowingly, not negligently, not through oversight. Knowingly. She found that the 7 LLC structures did not represent legitimate business tax management, but were instruments created and maintained for the purpose of concealing marital income from the petitioner and from the court. She found that the pattern of transfers over 7 years was consistent with deliberate and premeditated asset concealment, and that Derek Mitchell's signature on the financial disclosure, given the information available to him at the time of signing, constituted what she termed a fraudulent misrepresentation to the court. This finding was not a minor procedural notation. In Ohio domestic relations law, as in most American jurisdictions, a court finding of fraudulent concealment of assets in a divorce proceeding carries significant consequences. Courts can, in some jurisdictions, award 100% of the hidden asset to the innocent spouse as a penalty for the concealment. Judge Hines did not go to that extreme. What she did was more calibrated and, in its way, more total. The equitable distribution ruling assigned Sarah Mitchell 60% of all identified hidden assets, approximately $530,000. This was above the standard equitable threshold, and the ruling explained why in terms that were clear and documented. The court found that the years of financial control had materially damaged Sarah's ability to accumulate independent resources during the marriage, and that the equitable remedy needed to account for that damage in a way that a simple 50-50 split would not. Sarah was awarded primary physical custody of both Emma and Tyler, with Derek receiving scheduled parenting time. The ruling addressed Derek's claim that Sarah's history of mental health treatment indicated parental unsuitability with a directness that several family law attorneys who later read the ruling described as among the most pointed judicial language they had encountered in a domestic relations ruling. Judge Hines wrote that the use of a brief and resolved mental health treatment episode as a basis for challenging a parent's fitness, in the absence of any current clinical evidence of impairment or any documented impact on the children's welfare, represented a litigation tactic inconsistent with the children's best interests and the purposes of these proceedings. She dismissed the custody challenge entirely. Spousal support was awarded for 7 years at a level calculated to allow Sarah the economic footing to return to professional employment. The ruling noted specifically that Sarah's nursing license remained valid and her underlying professional competency was documented, and that the support period was designed to bridge the gap between 18 years of forced financial dependence and the kind of independent financial stability that her professional training made achievable. And this is the part that Gary Whitfield, in a conversation with a colleague months later, described as the moment he knew the pre-trial settlement conversation he had with Derek Mitchell had been the most important conversation of the case. The ruling included a referral. Judge Patricia Hines referred the matter of the 7 LLCs and the omissions from the financial disclosure to the Ohio Attorney General's Office for review of potential violations of Ohio tax law and civil fraud statutes. She did not make a criminal finding. She did not have the jurisdiction to do that. What she did was hand the documentation to the office that did. The referral, which was a single paragraph in the 43-page ruling, was the detail that, in the weeks and months that followed, would prove to be the most consequential thing in the document. Sarah Mitchell sat in the kitchen of her Rocky River apartment and listened as Linda Marsh read her the key findings. She did not speak for most of it. She asked clarifying questions in the places where she needed to understand the legal language. When Linda finished, there was a silence between them that lasted maybe 15 seconds. And then Sarah said, "What does the referral to the Attorney General mean for Derek?" And Linda told her honestly. It meant that the question of what he had done, and whether it constituted criminal conduct under Ohio law, was now in the hands of prosecutors, not a family court judge. It meant that the conversation about the 7 LLCs was not over. It meant that $887,000 in undisclosed income, accumulated over 7 years, was going to be examined by people whose job was specifically to determine whether what happened was a civil wrong or something more. Derek Mitchell's attorney Gary Whitfield filed a notice of intent to appeal the ruling within 10 days. The appeal was fully briefed and submitted to the Ohio 8th District Court of Appeals in January of 2020. In April of 2020, the Court of Appeals denied the appeal on all grounds, affirming Judge Hines' ruling in its entirety. Mitchell Comfort Systems entered financial restructuring proceedings in the summer of 2020 as the full scope of the tax and financial issues identified in the divorce proceedings began to generate consequences beyond the family court. The Ohio Attorney General's review produced findings that led to a civil settlement in 2021, the terms of which required Derek Mitchell to pay back taxes, penalties, and interest on the income that had flowed through the 7 LLCs during the 7-year period. The business his father had built, the business he had grown, the business he had believed was the armor that made him untouchable, it was not destroyed. But it was never again what it had been. And Derek Mitchell, who had walked into that courthouse in October of 2019 in a perfectly pressed gray suit, certain that a woman who had no money and no credit and no documented employment for a decade could not fight him. Derek Mitchell drove home from Gary Whitfield's office on the day the appeal was denied in a car that still had his name on the registration, to a house that was no longer on Birchwood Lane, and the laughter was gone. Entirely, completely gone. What replaced it? whether it was understanding or bitterness or something else that takes years to fully name, is something that the record does not show. The record shows only what the documents show, and the documents show a man who miscalculated, in the most fundamental possible way, the capacity of the woman he had spent 2 decades telling she was incapable. In the spring of 2021, Sarah Mitchell returned to work. She completed a refresher certification through the Cleveland Clinic's continuing education program, updated her nursing license through the Ohio State Nursing Board, and accepted a part-time position in a family health clinic in Rocky River. She was 47 years old. She had been out of clinical nursing for 13 years. On her first shift back, she walked into a patient's room to take a set of vitals, and the patient, a woman of about 70, looked at her and said, "Are you new?" And Sarah said, "No, actually. I've been doing this for a long time. I just took a break." She started full-time the following fall. By 2022, her sister Carol was describing her as a different person, not because she was a different person in any fundamental sense, but because she was fully herself in a way that Carol had not seen since before the marriage. She laughed. She made decisions. She bought furniture she chose herself and painted a wall in the apartment a specific shade of green she had wanted for years without being able to explain why. She had coffee with Joanna every 2 weeks. She called Dr. Reed every month. She planned a trip to the Smoky Mountains with Emma and Tyler in the summer of 2022, the first real vacation she had taken with her children that had not involved either Derek's permission or Derek's presence. They stayed in a cabin outside of Gatlinburg. Emma took photographs that Sarah kept on her phone. Tyler caught a small trout from a stream behind the cabin and was extraordinarily proud of it for approximately 3 weeks afterward. These are small things. They are also not small things at all. Because what the story of Sarah Mitchell is, beneath the financial documents and the LLC structures and the court ruling and the 43 pages of judicial findings, is a story about what happens to a person when, for years and years and years, every mechanism of their independence is quietly and methodically removed. And then about what happens when that person finds it all again. The savings account, the professional license, the savings in the account at the bank across town, $40 at a time. The lawyer found it through careful research. The forensic accountant. The journal entries are written at 2 in the morning in a notebook hidden in a box of textbooks. The 7-minute sit in the driveway after the school meeting, holding a thought that said, "I am still good at things." These are not the dramatic moments of a story. They are the actual story. The dramatic moment, the courtroom, the laugh, the 4 words, is only visible and meaningful because of everything that was built, quietly and deliberately, and at great personal cost, in all the years before it. This story matters beyond the specific courtroom and the specific people in it because the pattern it describes is not rare. Research from the Pennsylvania Coalition Against Domestic Violence has found that financial abuse occurs in 98% of abusive relationships and is the #1 reason victims stay in or return to abusive relationships. CADV, the National Domestic Violence Hotline, and multiple peer-reviewed studies in the field of intimate partner violence have documented that the systematic control of finances, denying access to accounts, restricting employment, controlling all household spending, maintaining sole ownership of all financial instruments, is one of the most effective and most invisible forms of control used in abusive relationships. 2 frequently cited studies of intimate partner violence survivors show that either 99% or 94% had experienced economic abuse, with 79% reporting some form of economic control, 79% reporting exploitative behaviors, and 78% reporting employment sabotage. Maryland, these are not rare cases. These are not extreme outlier situations. These are numbers that describe a pattern so common that it has its own research literature, its own legal framework, and its own advocacy community, and yet which remains, in the public conversation about abuse and relationships, far less visible than the forms of violence that leave marks you can photograph. What makes the story of Sarah Mitchell and Derek Mitchell different from a case that disappears into the statistical noise is the specific and very human element of the courtroom. The moment Derek Mitchell laughed. Because that laugh, brief, unguarded, satisfied, was the same thing that had been living in the architecture of their marriage for 18 years, finally visible in a room full of witnesses. It was the sound of a man who could not, even in front of a judge, fully suppressed the belief that the woman across the aisle from him was not a serious adversary. And it was the sound that, in the economy of that particular courtroom, on that particular October morning, in front of that particular judge, was the last miscalculation he would ever make in that proceeding. Because Judge Patricia Hines heard it. And as her 4 words made clear, she understood exactly what it meant. The conversation about what justice looks like in a case like this one does not end in a courtroom. Sarah Mitchell received a financial ruling in her favor. She received support. She received primary custody of her children. She received a referral that produced a civil settlement. These are real outcomes. They are outcomes that many women in similar situations never receive because they never find the $40 a week, the photographer's patience with a filing cabinet, the right attorney, the forensic accountant, the judge who was paying the right kind of attention. The structural barriers that Derek Mitchell built around Sarah's independence were, in her case, ultimately overcome. They are not always overcome. The National Domestic Violence Hotline estimates that a survivor of intimate partner violence leaves and returns to the relationship an average of 7 times before leaving permanently, and that the most commonly cited reason for returning is financial. Not love, not hope, financial necessity. The cage Derek Mitchell built was not unique. The outcome Sarah achieved was. And the gap between those two facts is where the real conversation about this story lives. Sarah Mitchell does not speak publicly about her case. She does not use her real name in the accounts of it that have circulated, and we have honored that here. She is, as of the time this account was assembled, working full-time in a clinical setting, living in the apartment in Rocky River that she has since furnished entirely to her own taste, raising 2 children who are, by Carol's account, doing well. She keeps a journal still, though what she writes in it now is different from what she wrote in the hidden notebook in the guest bedroom in Westlake. Carol said, in one of the conversations that informed this story, that the last time she read a page of the current journal, it was about Tyler's baseball tryouts and a recipe Sarah had been experimenting with and a plant she had bought for the kitchen windowsill that was not quite getting enough light and that she was thinking about moving. That's what she writes about now, Carol said. Normal things. Her things. Things that are hers. This is what the story of Sarah Mitchell is about, at its most fundamental level. Not a courtroom, not a laugh, not a judge, not a ruling. A woman getting back the things that were hers. A kitchen windowsill. A plant that needs more light. A Tuesday morning with nowhere to be, but where she chooses to be. Now that you have heard this story in full, we want to ask you something, and we want you to answer it honestly in the comments below. Do you believe that what happened in Judge Hines' courtroom was justice? Not just the ruling, the whole of it. The financial award, the custody decision, the AG referral, the 4 words, the fact that it took 18 years and a forensic accountant and a woman keeping journals in a hidden notebook before any of it came to light. Was it justice? Was it enough? What would it have taken for the outcome to have been different, earlier, or at all? And if you have ever sat in Sarah Mitchell's position, if you have ever been told, in words or in the architecture of the life around you, that you cannot fight, we want to hear that too. These stories matter. The comments on this video matter. The woman who watches this at midnight who needed to hear it matters. Tell us where you're watching from. Tell us what you think. And if you are new to this channel and this is the first story of ours you've encountered, please subscribe right now, because we have many more coming, and every one of them is the kind of story that the people who need to hear it most are the last ones who will go looking for it. We bring it to them. That is what we do. And the next story we are bringing you is already in production. It involves a woman who was told for years that she was the problem, a husband who was believed by everyone who mattered, and a piece of evidence so small that it nearly did not make it into the record at all. Nearly. Subscribe so you are here when it arrives. And thank you, genuinely, from the team behind this channel, for spending these 2 hours with this story. It deserved the time. So did Sarah.